Hello and welcome to the David Carrier Show. I'm David Carrier, your family's personal attorney, and you have found the place where we talk about estate planning, elder law, real estate, and business law. So give us a call, why don't you? 616-774-2424. That's 616-774-2424. We'll get your question, comment, or concern on the air. And I think we'll do it for free this week. How about that? I'm not even going to charge you for it. Well, questions about estate planning. That's that wills, trusts, and probate. You know, everyone wondering what's, it's the good thing to do is to avoid probate. Why is that such a great idea? Give us a call. I will tell you. Elder law. Okay. That has to do with that teeny tiny little bitty part of estate planning that has to do with you while you're alive. It always seems to me, I don't even know what you want to call it. Funny that that folks who plan for after death, but we haven't figured out how to get there yet. And we live in an environment right now where the lowest estimate of people needing long-term care comes from the National Institutes of Health, which is about 70%. And by long-term care, skilled care is what they say. Skilled care is average of 3 years. And 20% need it for 5 years or more. Now, it's not all nursing home care. It's not all residential. You got to be in a long-term care facility stuff. I want to be very clear about that. But you will need that care, 70%. Now you say, well, we're part of the 30%. I say, well, yeah, but here's the thing with that. This is at age 65. So if you're 65, 70% of folks alive at 65 will need the care. But you know something? By the time you get to be 70, 80, a lot of those people are already gone. And so the percentage goes up. I know, no math. No math this early in the morning. Please stop. But anyway, that's the real deal. And we're trying very hard to make it possible for more people to plan ahead for this. We really want to get the long-term care coverage that's available through your tax dollars at work, right? We want to make that as available as income. And by that, I mean Social Security, right? I mean, right now, who doesn't get Social Security? Well, you got to work and all that, or have a spouse that did. And so now you get your Social Security. And nobody argues about that, or should. I mean, I know people still try to stir the pot and try to pretend that there's some people who are actually against Social Security. But I mean, by now, everybody knows what bunkum that is. So there's that. And then there's Medicare, of course, which provides for your health care. Well, nobody wants a financial statement from you when it's time to get your knee replaced or you have a broken hip or something like that. They don't say, oh, sorry, you've got too much money. Come back and see us later. But they do that with the long-term care, you see. And what we're trying to do, what we are doing for lots and lots of families, thousands of families, is we're making sure that irrelevant considerations should not become relevant. That's the deal. That's what that elder law is all about. And don't you believe the spend down stuff? Don't be buying into that, please. Or if you have better yet, if you have a question about it, give us a shout, 616-774-2424. We also deal with real estate and business law. More areas where misconceptions, repeated bad advice. Is it fair to call it laziness? I don't know. But people tend to repeat the same old thing over and over again. By that, I mean, attorneys tend to, accountants tend to. Not everyone all the time, but you do see repeated bad advice over and over again when there's better advice out there. There's better things that you can do. The more you dig into it, in compliance with the rules. See, this is all about following the rules. That's what we're trying to do here. That's what we are doing here, is following the rules, because there's plenty of opportunity within the rules for you to do just fine. You don't have to go outside the rules. And that's what happens, See, that most people who get in trouble with IRS or all the rest of this, most people get in trouble with these folks could have done the same thing following the rules. Okay, if they followed the rules, they'd have gotten the same result. but they don't follow the rules because they don't know what the rules are. They think the rules are so oppressive and shouldn't apply and all the rest of this stuff that they go ahead and they break the law. They violate the rules and didn't have to. Are you with me on this? I mean, it's a very, what do you want to say? Very disturbing, very unfortunate reality that people do violate the rules when they could have complied with them easily. Or if not easily, you could have complied. You could have gotten there. There's a good friend of mine from the military who went to work for the IRS as a prosecutor. And I remember him telling me once upon a time, this was probably 20 years ago. He's like, he goes, most of the people I put in jail, and he was doing criminal prosecutions at the time for the Internal Revenue Service. He goes, most of the people I put in jail could have done it, could have done the same thing, could have gotten the same result or very close to the same result legally. They could have done it. And you see, it's like there's ways to do this stuff, okay, in compliance with the rules so you don't go broke. Okay, there really are ways to do it. And so often you see the fly-by-nighters, it's terrible. Like right now, the big thing, I don't know if you keep up on this stuff at all. But it's you may have seen these things, get $26,000 per employee. Okay. And it's on the various TV and radio and stuff like this, the earned income tax credit. Excuse me, the employee retention. That's a different one. So many credits, I'm mixing them up. It's the employee retention tax credit. Okay. Now there's ways to do the employee retention tax credit. And when we get back, I'll explain what that's all about. But the point is, I've become familiar in the last 6 months or so with various folks who are either pushing it, as something you should do as an employer. This is a COVID thing during the COVID for small businesses. And you have a lot of people who are out there now pushing folks to do the ERTC, however you want to call it. And I think that's a great idea. I think it's really important to do. I'm involved in it, full disclosure. A buddy of mine he and I set up a national law firm to process these cases. But the thing is, now I see how other people are doing it. And it's like, number one, there's a lot of CPAs out there, and it's not just CPAs, tax preparers, lawyers, everybody else, giving really terrible advice because they didn't read the whole thing. I mean, you think to yourself, how in the world can this be? How can you have people just giving advice without even reading the law? But you've got that. And then folks who are processing these cases, right? And they're not even doing the barest due diligence on it. It's like, what? It's like setting a minefield, that you on the way to school or something. You're going to walk down it, tomorrow, and it just blows your mind. But anyway, the point is with the ERC, and I'll talk about this on the next thing. And by the way, if you're bored by this because you've already seen too much employee retention tax credit, or it just doesn't have anything to do with you, right? Is a real easy way to distract me and put me down a different path of interest. And the way to do that is call 616-774-2424. Give us a call. I'm more than happy to talk about anything that you would like to discuss if you don't find this stuff interesting. So you're listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. And I like to think we are sort of a family around here. People listening. So 616-774-2424. 616-774-2424. That gets you to the studio. You can always drop me an email. Love to get the emails. David@davidcarrierlaw.com. How simple is that, huh? Easy, simple. Or just go to the website, davidcarrierlaw.com, and you can find out about our workshops, the new things we're doing. We're doing some pretty interesting, well, it's interesting to me anyway, interesting things in terms of making a lot of this stuff more affordable, the estate planning and what have you. It's a new initiative that we're just starting now to leave no family behind. I mean, if you want to get this done, and I'm talking about the high-end planning that we've always done, but at a much more reasonable cost, much more reasonable, much more, I don't know what you want, accessible cost, and we're not limiting it to anybody. I mean, it's like, hey, you can do it like this, you can do it like that, different options. That's the key. Just give us a call about that. That'd be fine. But what I'm talking about this morning is the employee retention tax credit. Employee retention tax credit. This was a COVID pandemic program that involves, it's one more of these shovel the money out the door as fast as you can and see what happens programs. But unlike a lot of the programs that are still out there, I mean, there's still billions of dollars that local governments have that they haven't spent yet. And they're trying to figure out how to spend it and all that. But this was a program, I kind of like it, frankly, because it's right in the name. It's about retaining employees. If you remember back in the day, way back then, with the COVID, what we were afraid of, what the government was afraid of, was that people would get laid off, that employers would say, look, if you can't come to work, if I've got to mask up everybody, if I've got to socially distance, all these things that are just wrecking my business, and there's no money and everybody's sheltering in place, right? Then I can't keep the business going. If I can't keep the business going, I can't pay people. If I got no money coming in, there can't be any money going out. See, that was the problem. The immediate answer to that was the Paycheck Protection Program. These were those loans. Okay, so that helped. But then after that, and that was kind of a shot in the arm. But after that, there was this, in addition to this, okay, so they're not, see, some people think that if you got one, you can't get the other. You can get both. That's not the issue. You have to balance. You can't double dip. That's right. You can't double dip. But you can get both. Although originally the law said you had to choose, that was over and done within months, and you can get both. It's just a matter of not double dipping. Okay, so the idea here anyway was, if you're a small business, okay, you're a small business, and you got whacked so that your revenue went down. Okay, the amount of money that you brought in went down by 50%. This is in the first year. Then they would give you up to $5,000 per employee. Okay, this is in 2020. $5,000 per employee that you had on the payroll, right? And that would be 50% of what you paid them. Okay, so think about this. If you're an employer, federal government says, hey, guy, if you kept these people on, if you keep them on, we'll spot you 50% of what you're paying them after the PPP. Take care of forget about that. We're not double dipping. But if you dug in your pocket and your revenue was down, the amount of money you had coming in was down, but you kept your people on the payroll, right? Then we'll give you 50% of what you paid them, to a maximum of $5,000 for the whole year per person. All right. And I am grossly oversimplifying the rules. Okay. So don't call me up and say, wow, it's quarter by quarter. And yeah, I know. And I didn't say that you add in healthcare benefits and the other expenses. And yeah, I didn't say any of that. I know. But let's just try to get the big picture here. Okay. So it was $5,000 per employee that you kept on, even though your business was down significantly, half of revenue. So if revenue was, plummeted, boom, then you could get $5,000 per employee. Well, that's wonderful, huh? That's pretty good. And then it wasn't working because it was too complex. People didn't quite understand it. and all the rest, and it wasn't that much money anyway, so people weren't applying for it. And then the government said, okay, and at the same time, what you had happening was what they feared, which was people were getting laid off. See, if you're laid off or were laid off during the pandemic, what did you do next? Well, you went to the unemployment office. Holy cats. The unemployment office wasn't set up to deal with all these people, you see? And so you had not enough money in the unemployment system, and you had methods and practices in the unemployment insurance agencies that could not cope with all the people who were showing up. So they said, okay, we're going to make it better. We'll make it 70% per quarter. So in 2021, the idea was you could get $7,000 per employee per quarter for 4 quarters, all 4 quarters. Now they cut that back and they said, nah, forget about the 4th quarter. We'll just do it the first 3 quarters. Okay, fine. So now it's $21,000 more in 2021. If your revenue was down, not by 50%, which is what they said 2020, but by 20%. So if you were bringing in 20% less money in 2021 and you still kept your folks on, still kept them on, okay, then you could get $7,000 per employee. All right, $7,000 per employee, so long as that was 70% of what you paid them. Okay, so before it was we'll pay you half over 3 quarters, maximum of $5,000, and now we're going to do, now we're going to change it. So it'll be a little bit different. So it'll be $7,000 per person, 70% of what you actually paid them. So this is the thing with the ERTC, right? You had to keep your people employed, right? You had to keep it going, even though you had significant reductions in income, even though you're taking in less money, right? And I said income, I meant revenue, gross receipts, the money that showed up, the money that came in the door. Okay, if you got less money coming in the door, okay, less money coming in the door, then you would qualify. Now, everybody knows this. Okay, everybody gets this. CPAs get it. Everybody gets the idea that if your revenue was down, then you're entitled, right? Then the government will say, attaboy, you kept the people on, attagirl, atta whoever, good for you. You kept your people on, so we're going to help out with that because we wanted you to keep the people on. All right. That was a good thing that you kept everybody employed. So we didn't have to worry about the unemployment, and the labor force stayed together and your business stayed open and you did all these good things that we wanted you to do. So we'll help you out. That's the whole idea behind the ERTC. Okay. When we get back, I'll tell you the part that nobody seems to get, very few people seem to get, and how it's a salvation nowadays for an awful lot of small businesses. That's what I'm finding. Give us a call, why don't you? 616-774-2424. You're listening to The David Carrier Show. Welcome back to The David Carrier Show. I'm David Carrier, your family's personal attorney, and you have found the place where we talk about estate planning, elder law, real estate, and business law, plus just about anything else you want to talk about. If you give me a call at 616-774-2424. Of course, you can always drop us an email, david@davidcarrierlaw.com. And what else? How else can you get hold of? Oh, yeah, you could go to the website, davidcarrierlaw.com. You could do that. Or you could call the office directly. If you want to do that too. 616-361-8400. 616-361-8400 if you want to call direct. And if you're driving by the East Belt Line, yes, we're the building with the old car out front. And I know that it's bad weather for driving old cars around, but there you go. It's under cover. I get a lot of hassle for that. You know what I mean? A lot of other folks are, hey, how can you leave that old car out there all winter long? And the answer is I start it up every once in a while, keep the oil moving around in there, and like that. But you know something? No one would know where the heck I am if I didn't park it out there. and it's under cover. It's under what they call a courtier, and probably not how you say it. But anyway, yeah, we're the ones with the blue and white 56 station wagon. So if you're wondering where we are, that's where we are. You can always so you can call us, you can email us, or you can just walk on by and say, "Hey, oh yeah, let's drop off a message." There you go. Anyway, what were we? Oh yeah. If you have a question, comment, or concern, give us a call, 616-774-2424. And just to show you the breadth, the wide-ranging questions that we answer, we did get a call from Linda, who wanted to know what the income cutoff was for her elderly husband, for food stamps this year. And the answer is $3,052 a month, which I didn't have to research at all because I knew it right off the top of my head. Okay, maybe not. Anyway, if your income is more than $3,052 a month and you're older, meaning above 60, that's a sobering thought, isn't it? Don't you love being elderly? It's wonderful. Anyway, if you got more than if you're older than 60 and he's on Medicare, so he must be, unless he's disabled, in which case maybe he's not. But anyway, if you're over 60, there are some other tests. Even if you have more than $3,000 a month coming in, there are some other tests, net income test and asset test, that can be used to determine your eligibility for the SNAP benefits, also commonly known as food stamps. So there you go. You see how helpful we can be? Isn't that helpful? You betcha it is. So what we're talking about today is the ERTC, the Employee Retention Tax Credit. And this only applies to you. This is only of direct benefit to you if you're running a business, or if you were running a business, or if you bought a business that was running during 2020, 2021. But I think it's important everyone should know about it. Like, maybe somebody who was running a business, because most of this money got left on the table. California vacuumed up hundreds of billions of your tax dollars for what? Read some of the stories about what they're doing in California. It's insane. Okay. But you're paying for that. And just look around you. Look at what they're spending your tax money on. Nutty stuff. And so my thought is that if some of those tax dollars can go to the small business owners who kept businesses going, who kept their neighbors employed during the pandemic, and now they're getting whacked with inflation, right? And recession and every other craziness. Well, what's so bad about them, getting a little bit of their taxes back? That's the point. You see, it's a tax credit. It's a refundable tax credit. So they give you back the money that you paid in plus. Okay, so it's a great benefit if you're a small business owner, right? It is. It's just. But here's the thing: your business. There's two tests. The first is, did your business go down? Well, that's not really what it. That's what everybody says, but that's not really what it is. It's, did the amount of money that you took in go down by a certain amount? Now, if it did, slam dunk, easy, you qualify, boom, done, no problem. Even the CPAs know about that. And I apologize to all CPAs in the audience because I'm going to slam you a lot. But when you do it on the numbers, you're fine. What the law actually says, though, is that the reduction is not only based on that. It could be based on that. If you pass that test, you passed. But there's another test that's just as good, just as effective. The thing is, most people, we got our food stamp person on the line. I tell you what, if you just want to find out what I have to tell you, I looked that up. I said I knew it off the top of my head. I didn't. I actually looked it. I actually looked it up. So if somebody wants to get in a in-depth discussion about food stamps, I'm not the guy. All right. If you want a particular question, I'll find out. I'll get you the answer. But I really can't, I'm really not qualified to discuss that in depth. You want to talk about Medicaid? Fine. ERTC? Fine. You want to talk about There's a whole lot of other things we can talk about, and I can give you a snappy answer. But food stamps aren't one of them. But Linda, if you do have a specific question, just leave it with Shelby. She'll get it to me, and I'll pass that on to you. Okay, I'll look it up for you. All right, there you go. So here's the deal with the ERTC, the second test, the one that everybody has ignored, is what it looks like, and the one that's not being applied correctly, in my opinion. And that is what the law says is if you had a full or partial suspension of a line of business, then you qualify. Full or partial suspension, even though your business stayed open, even though you brought in the same dollars. Let me give you an example. So we have a client who makes the black boxes, avionics boxes that go on Army helicopters and jet Air Force planes and everything else. As you might imagine, putting together these black boxes is kind of difficult, okay? It's super high-tech stuff, very difficult to do. And there's a lot of intellectual property that goes in there. There's a lot of engineering that goes into making these things that tell the airplanes where they are and helicopters and who to shoot at and all. I don't even know what they do, okay? They're just, mystical magical stuff, okay? These black boxes. Because they're so super high tech and they use the chips and et cetera, et cetera. Now, the thing is, during the pandemic, they couldn't get the chips. They couldn't get these, supply chain issues and this and that. They could not get the chips that they were using, the high tech processor chips. Okay. They couldn't get those. But they didn't want to close up and say to all their engineers, go home and, too bad for y'all. What they did was they kept everybody on and they pivoted. They went from selling, from building and engineering and selling these to the Army, military, these high-tech avionics boxes to selling large quantities of generic chips, memory chips. They could still get them. They had all kinds of contacts, right? And they were using some memory chips anyway. And now what they were doing was this other line of business, right, which was just selling memory chips to whoever wanted to buy them. As it happened, the amount of dollars that came in the door was greater than when they were selling the avionics boxes, the black boxes. Are you with me on this? So they're selling the black boxes and they were making, say, $100. And now they're selling chips, right? And instead of $100 coming through the door, now you have $200 are coming through the door. But if you're making these black boxes, okay, then a lot of that is the intellectual property that you were using, and you're making money on that. Over here with the generic memory chips, you're not making any money, hardly any money, okay? But the dollars coming in the door are greater. So, in fact, you've got huge, and this is what was happening to these folks, huge economic dislocation, keeping people on to do nothing, basically, to keep them with the paychecks, so you kept your workforce, which is all what the government wanted, which is exactly what they wanted you to do. Do you see? But you were getting more money in the door. They weren't making any money, right? But the flow of dollars kept up. So they qualify under the second test. Do you see? Instead of being able to do what they did before, because of the governmental orders, and that's the other thing you have to have is a governmental order that makes you move in that other direction. So we researched, we found the governmental orders, all the rest of it. They qualify, even though everyone told them, oh, you'll never qualify. They did qualify, as a matter of fact. And that's been our experience with the ERTC over and over again. When we get back, I'll explain exactly what the difference is between the way it should be done and the way it looks like an awful lot of people are, in fact, doing it. You're listening to The David Carrier Show. I'm David Carrier, your family's personal attorney. Okay, welcome back to The David Carrier Show. I'm David Carrier, your family's personal attorney, and this is the place where we talk about estate planning, elder law, real estate, and business law. Let me Linda called back. She had some additional details. So let me ask you here's a website for you. If you go to www.snapscreener, SNAP screener, SCREENER.com. And there's a software tool there that'll help you determine what your eligibility is. Okay. And it's got all the, income and how much did this cost? How much did that cost? And it gets you down to a number. I made some guesses about your income and what have you, and I came up with $23 a month, same as you did, same as they did. But I don't actually know what the numbers are. So go to that www.snapscreener.com and go ahead and run it through there. Okay, that's the best advice I got for you. Just going back now to, I'm going to round out with this employee retention tax credit. What is it? It was a COVID thing that they started to keep people employed. It was a way to help employers keep workforces intact. Okay, the people that you had working for you, how are we going to keep it intact? And one way they did it, determined eligibility, was say, hey, were you taking in fewer dollars than you did before? And there were some tests for that, and it was easy to apply because it's pretty obvious. You look at bank deposits and whatnot, you can figure that one out. More difficult, though, and this is why, frankly, this is why I got involved, how I got involved. They reached out to me and said, hey, can you help us with this ERTC thing? This is one of the big companies that advertises all over the place. And we're like, yeah, sure. We'll, tell us what's going on here. And over the course of a few months, we worked it out, figured it out. And the way it works is there's the numbers, right? And if you pass on the numbers, that's great. No problem. But most people don't, because most small businesses didn't just sit there and take it, right? They scrambled around. Like, this is what small business people do, right? If you give them, lemons, they make margaritas out of them or something. And that's what people were doing. So they had a line of business, but because of the governmental orders relating to COVID, they couldn't do that business anymore. So if you're in hospitality, okay, and you had a dine-in and then you went to DoorDash, okay, and the government said you can't have more than 50% occupancy, 25%, 50%, 75% occupancy, you're going to qualify. I know your CPA will tell you you don't qualify, but, well, what do you want from CPA? And they're right. The CPA is correct. You won't qualify on the numbers. But that's only one of the tests. There are two tests. And the second one is, did you have a full or partial suspension of a line of business? And IRS came out with all kinds of guidance and FAQs and stuff that have been routinely thrown out of court because they did not comply with the Administrative Procedures Act, which is how our government, at least governmental agencies, make regulations. They didn't abide to any of that. So we're back to, what does the law? It's amazing. It's kind of refreshing, actually, because instead of wondering, well, how does an administrative agency apply? What do they? Because this is how it works. Most of the time when you're dealing with the law, you're not even dealing with the law. What you're dealing with is, what did the administrative agency wish that the legislature had done? Okay. And now you get all these regulations, quote unquote, interpreting the law. And actually, in lots of cases, it changes it. The Secure Act with the IRAs and the Secure Reform Act, right? It was so different. What the IRS said the law meant was so different, right? Even the IRS admitted it was different enough that they delayed enforcement of their regulations. Okay, because it was just so. It was like, what are you talking about? What are you talking about? How does that all work? And they said, well, yeah, we can understand why you wouldn't understand why we came up with these regulations, because it's different. so different than what the law was. And like nobody agreed with them. So they backed off, at least for 2023. Now it'll kick in 2024. It just, and listen, I'm more than happy to go into detail on that, but I'd lose the other half of my audience. Even my relatives would hang up if we if we went too deep into the numbers. But if you're interested, it's a good example of how the law says one thing, the administrative agency, in this case, same administrative agency, the IRS, says, well, we wanted them to do this, so here are all these rules. And it's like, wait a second, that's not what this says. That's your putting all kinds of other stuff on there, right? And the courts have let them get away with this forever and a day, so they still get away with it. But the nice thing and interesting thing about the ERTC has been the courts haven't put up with it. Instead, what they've said is, no, all that stuff that the IRS, came up with, on the spur of the moment, in reaction to what Congress did, okay, we're not going to listen to it because you didn't comply with the rules. You didn't comply with your own rules in terms of putting out these regulations. So we're going to go back to what does the law actually say? And the good news is for many, many small businesses, and we've dealt with thousands already, saving lots of money for the businesses that kept people employed. See, that's the thing. People aren't buying boats with this stuff. People are not, they're not blowing the money. They're using it to keep the people employed, which is the whole idea. It's just that by now you would have thought, hey, we've recovered from the pandemic. Talk to almost any small business person. You'll find out that the pandemic is still with us. The effects of the pandemic are still with us. Okay. And given everything else that's going on, this money really is manna from heaven, if you want to look at it that way, to keep small businesses going, to keep people employed. Very, very important stuff, in my opinion. Give us a call, why don't you? In the meantime, you've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Hello, and welcome to the David Carrier Show. I'm David Carrier, your family's personal attorney. And you have found the place where we talk about estate planning, elder law, real estate, and business law. So give us a call, why don't you? 616-774-2424. That's area code 616-774-2424. We'll get your question, comment, or concern on the air. How easy is that? We've got Brett on the line to get started this morning. Hello, Brett. Welcome to the David Carrier Show.
Good morning, Dave. How are you this morning?
I'm just perking and working and having a ball. Sunny
Wonderful.
Day, beautiful day.
It is. I'd like to change the topic real quick for a second.
By all means.
I have a second. I have a second house that has zero debt, and I built it in 2000.
Okay.
What I'd like to do is, I'm curious if I can sell this house and reinvest it into more real estate without getting into the capital gains, because I have not lived there for 2 years.
Mm-hmm. Well, it's 2 out of the last 5 years, right? So did you live there at all?
Yes.
Well, when did you live there?
No, I have not. I built it originally, bought the property next to me and built it for my mother as her health was failing.
Gotcha.
And she managed to live in there for 2 years and passed away at the end of this last year.
Got it.
So, I really didn't have designs on doing it, but there it is.
Yeah. So what you do is you tot up all the expenses that you had building the thing. Okay. And I don't mean your personal labor, because you can't claim that. But the cost of the land, the lumber, everything else, all those what we call capital expenses. And let's say that comes to $100 and you could sell it for $200. And now you've got $100 of gain on that property. Okay. And you're not a dealer, so this is not trade or business. We don't have to worry about ordinary income. You've had it for more than a year, so it's long-term capital gain. This is what I'm thinking. And so your maximum tax rate is going to be 20%. But the question is, and See, there's a real obvious answer here. It's called a 1031 deferred like kind exchange. So you go to sell the thing, you park the money, the proceeds with the exchange trustee. Most title companies, are set up for this now. And if not, they're outside agencies, they're outside companies that'll do this for you. They'll be your exchange trustee. And by the time you close on the first property, you have to identify certain properties that you want to buy in replacement. You may not have those under contract yet and wouldn't until you actually sell the first one. But then what you can do is you can take the proceeds and reinvest it into real estate. Now, the gain that you have on the $100 a gain reduces your basis in the new property. Okay, so that when you go to sell the new property, then you're going to pay the tax at that point. But the idea is that because you started out invested in real estate and you wound up invested in real estate, we're not going to tax you in the meantime. It's a good idea because it makes everything more fluid. It reduces the tax consequences of you making a more efficient, a more intelligent decision on how to employ your money. So that's why the IRS likes it. Now, the question I would have for you is, what is your and let me get the rates for this year. What is your tax rate right now? Right? How much do you pay? Do you know how much you pay in income tax? You know what your percentage is?
Oh, no, not off the top of my head. I know we pay in a little more than what we should because we get a little bit back at the end of each year.
Right. So okay, so you're married and you file jointly, is that right?
That's correct.
Okay.
Yep.
Now, do you have more than $83,350 of income per year?
We do.
Okay. Do you have between 83,000 and 517,000?
That's correct. Yep. No, between the two of us, about 150.
Okay. So if you were under 83, right? If you're under 83,000, yep, then you would have zero tax on the capital gain. Okay. As it is, you'd be paying tax at a 15% tax rate between 83,000. Okay. If your income is between 83 and 517, married filing jointly, then you're looking at, and I apologize, I'm looking at the 2022 numbers. For 2023, it's 89,000 to 553,000 is where you get your 15% tax rate. So you'd be paying tax at a 15% rate. About how much gain are you looking at, if I could ask?
There's a considerable amount. I built the entire house myself, from excavating the foundation to pouring the concrete to all the construction and finish. I'm a carpenter by trade. So,
got it. So what would you sell it for?
When you take my labor out of it, there's a fair amount.
Yeah, but give me a. Let's say it was 200,000. Okay, let's say you'd have 200,000 a gain. That means at 15% tax rate, you'd have 30,000 of taxes to pay. Okay, right. And then right. So what you do is you look at the 1031, right? You look at the things that you have to do to qualify for the 1031 exchange, and you say to yourself, well, is it worth putting off paying $30,000 of tax, until I sell the second thing? And the answer is darn tootin'. Yeah, I mean, 30,000, that's a lot of money. Yeah. So, and it'll cost you a few $1,000s for the exchange trustee and all that. But that's really, that'd be the way to go. It seems like to me. It's what they call a deferred like kind exchange, 1031 exchange.
So if I put the house into a trust and then sold it, reinvested into more real estate, is that trust does that go to my daughter when I go? I'm roughly 60 now, so
Yeah. So here's how it works. You personally are not putting it into trust. In order to get the, and I'm not making a comment on how you have your estate plan set up. You can still do it. But the key is you have an exchange, what they call an exchange trustee. The idea was that if you touch the money, okay, it blows the deal. There's no deal. If you touch the money, because then you had the money, you could have spent it and you decided not to spend it. What the IRS wants is for you never to have changed your position. You were invested in real estate, you never had cashy money, and now you're invested in real estate. So it's like it's always invested in real.
So that 30,000 rolls over to the sale of the next property.
That's it. Now here's the key, right? Let's say you roll it into, and you keep rolling it, and people do this, right? Every time they sell it, then they get an apartment house, then they get something else, and get something else, and which is fine. And then when you die, right? If you've held on to the property through death, then you get what the kids get, what they call stepped up basis, which means that you never pay income tax on any of it, or a capital gain tax. Nobody pays the capital gain tax on any of the gain, because when you die, all of your assets are inflated. The basis in the assets is inflated to current fair market value. So let's just play this out. You bought it for 100, you sold it for 200. Now you buy something for 300, but as far as they're concerned, right, it's only 200. Now that goes up, and now your $300,000 property is worth $500,000. But now you die, and so when it gets sold, the kids are treated as if they paid $500,000 for it. So there's no tax, there's no gain, no tax. And I'm at the end.
See.
Okay, the music's going to start here in just a sec. If you want to hang on, it might be a good idea just to go over that one more time, if you don't mind. Just to be real clear about how that works. Okay, you've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney, and you have found the place where we talk about estate planning, elder law, real estate, and business law. So give us a call. Why don't you? 616-774-2424. That's 616-774-2424. And we'll get your question, comment, or concern on the air. You can also give me a call or drop me a line at on the email. That would be david@davidcarrierlaw.com. david@davidcarrierlaw.com. Or you can just go to davidcarrierlaw.com. All kinds of great stuff on the website. Hope you like it. We're talking to Brett. Brett, is Brett still with us?
Yep, I'm here.
Okay, great. So here's the deal. Just want to recap that when you have a property with capital gain that's been built up, and you decide, hey, I don't want to sell and pay the tax on the property. Instead, I've got it invested in a commercial, residential, agricultural, farmland, whatever it may be, right? And at the end of the day, I want to still be invested in real estate. I just like $30,000 more real estate to be invested in. No problem. That's the like-kind exchange. Now, there are basically three ways to do this. Only one of them is really popular. The first way is what they call direct swap. So you find somebody who wants your house or your mom's house, and that person who wants your mom's house just so happens to have a piece of real estate that you want. Okay, swap them, and then you adjust for the dollars. The problem with that is, how likely is it that you're going to find somebody who's got what you want? So that's hardly ever done. There's what we call a reverse swap, which I'm not going to get into because hardly anybody does it, and it gets to be more complicated. The thing that most folks do is what we call a deferred like-kind exchange. The deferred exchange means that on day one, the first day you sell the property. That's what kicks off the clock starts ticking on day one. When you close, not when you enter a buy-sell agreement, but when you close on mom's house, the house you built for your mom. All right. In a month and a half, within a month and a half. Now, it's a good idea to have this done before you close on mom's house, but you got 45 days to identify the replacement property. And you can identify multiple properties. We used to do this is back in the 80s. We used to do like the phone book, but you can't do that. It's got to be like I think it's 3 properties now is what the limit. But then you have to close on one or more of the replacement properties within 6 months of the original closing. So you've got 180 days, and it's not 6 months, it's 180 days, roughly 6 months, to close on your replacement property. And then what you do, as you point out, is you reduce your basis in the new property by the gain that you had in the other one. Here's another thing, and this doesn't apply to you, Brett, but if you're carrying debt, if someone was carrying debt on the property that you're selling, you have to take as much debt on the new property, okay? Because if you don't, then they're going to treat that as that's going to be taxable, any reduction in debt. So if you owed $20,000, then you still have to owe $20,000 on the new property. Otherwise, they're going to treat it as if you had received $20,000. You pay the tax. You pay the tax on that. And like I say, back in the day, we used to we used to do the phone book. We really can't do that anymore. That was the DC phone book. Now, the other thing that's developed since the 80s, it used to be kind of the Wild West, because you had the law, but you didn't really know what the IRS would approve or wouldn't approve. So you had to tiptoe around the thing, be very careful. In, I want to say it was 89, 90. No, earlier than that, maybe 87, 87, 88. They came out with what they call safe harbor regulations. And it really eliminated the Wild West element of it, because now instead of wondering what the rules were, they said, if you do this, we're going to approve it. If you do it like this, and it's really much less anxiety, much lower anxiety when you do these things. It's just much more regulated and much more easy to get what you're entitled to, which is namely that $30,000 or however much it is, whatever the deferral is on the taxes. So it's and in order to do it, you have to have what they call a qualified intermediary, or a exchange. Qualified intermediary is what the IRS calls it. Exchange trustee. If you go to a title company and say, "Hey, I want to do a like-kind exchange," do you have a exchange trustee? Then generally, and that's just the person who holds the money in the meantime. All right, for this 180 days until you.
I see.
Okay, so and you're not limited. See, the other beauty thing with this is you're not limited to the holder of the real estate. It could be you personally. It could be your qualified sub-S trust. It can be a corporation. The like-kind exchange is generally available. So it's not the situation that you have to take on any personal risk, right? When you do this, it's you can have it incorporated. You can have it with an LLC. You can have it with your trust. That's all. That's all okay. You're good to go. And here's the thing. This is why I think we're going to get more interest in the 1031s, because when the capital gain tax is very low. So like if I asked you, well, how much income do you have? If the answer was, 80,000, 85,000, well, you wouldn't be paying any capital gain at all, right? Instead of 15 or 20%, So an awful lot of folks who used to do the capital gain, used to do the like-kind exchange, didn't do them. And when in 87, when George Bush Sr. redid the tax code, they eliminated the reductions for capital gains, right? So back then, you would be paying like 43. This is what sticks in my head. I think it was like 43% was the maximum federal tax on capital gains. Well, holy Toledo, if you're doing a deal and you sell your business or you sell your real estate and you took a 40% tax hit on it because there was no differential, you see? And what happened was it locked people in. See, if you had to give up 40% of the value of this place, the house that you built for your mom, you wouldn't sell it and put it into more productive use in a commercial property or whatever else you're planning to do with it. Instead, you just,
Right.
I hate it, but I'll lump it. I'll just keep it here. Well, all right. Well, that's
Right.
inefficient. That's bad that's bad for everybody. Okay. And then when you die and it goes to your kids, then the kids can sell it and not pay tax. But death is a heck of a thing to wait for in order to sell real estate. Oh my goodness. That's the time. That music means I got to get out. But you get the idea, right? So
I do, and I thank you very much for your time this morning.
Very welcome. Thank you, Brett. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. And we're going to look at some of our, going back to the mailbag here, looking at some of these things. Elderly mother suffers from dementia, lives in her house with a caregiver. 2 days ago, neighbor asked if the caregiver could take care of his son because of a judge decision. He'll pay the caregiver. I want to help. I'm afraid if anything happens to the child, sue my mother, and mother's insurance already through the roof. Could I give him a paper to sign that we are not liable for anything? Well, you can give him sign anything, but I wouldn't do this. I'm just saying. I mean, it's nice to be nice, but the caregiver that is living with your mom, I mean, is it a family member? I mean, who is it? No detail on that. But what do you, is the child supposed to come next door and stay at your mom's house while the person's taking care of your mom? Now she's got two people. It's nice to be nice, but you can have them sign whatever piece of paper you want. That they're going to blow right past it. You know what I mean? So I wouldn't. This is one of those where, like I say, it's nice to be nice, but my goodness, it would be certainly would be a difficult kind of thing. Okay, I wouldn't. I hate to be a jackwagon about the thing, but jeepers, Okay, received letter of conservatorship. We're guaranteed full conservatorship. Now what? Good question. Ask your lawyer. Oh, I don't have one of those. Okay. Need to sell a property owned by the person I'm looking after, my brother. I was told two types of orders. Orders necessary to go through court before you sell the conservatee's property. Order that gives him full authorization to dispose of the conservatee's property. I received the latter. They're full conservator. Can I sell the property? The answer is no. I don't know who told you that, but generally speaking, I can't remember getting letters of conservatorship that didn't have the box checked that you have to get a court order to sell real estate. I suppose you could have, but just saying I'm full because generally what happens is when you have somebody who's in need, you get an emergency order, a temporary guardianship, temporary conservatorship that gives you basic authority to deal with stuff. Then you have the full hearing. And really, there's not much difference between the limited conservatorship and the full conservatorship. It's just that you had the hearing, okay? And then the judge made all the necessary findings. So now it's on a permanent as opposed to an emergency or temporary basis. That's really the difference. And believe me, you don't want to be selling real estate or anything like that, any of those big things, without getting the approval of the court if you're going through conservatorship. Okay. Because if you do something like that, the judge finds out, which the judge will find out because you're going to file an accurate accounting, and then you didn't satisfy whatever criteria the court thought you should have satisfied. Yikes. Now you're in trouble. And you don't want to be in trouble. You're already doing the conservatorship. That's enough trouble. Okay. Let's do it. Let's do it correctly. Okay. Let's be safe. Let's get the judge to approve things. If you're going to do the conservatorship route. Now, this is another reason, frankly, why I'm not a big fan of conservatorships, right? Because before you turn around, you got to ask permission for everything, or you should. You should, because you got the judge looking over your shoulder, or the court looking over your shoulder at every step along the way. So if they're there already, right? I mean, there's the old saying, it's easier to get forgiveness than permission. Okay. But that doesn't really I would not advise you to apply that maxim when it comes to being a conservator or a guardian, mostly conservator. Guardian, yeah, go ahead. But guardian or conservator, if you're a fiduciary, okay, you're not going to get forgiveness. You'll get jail time. It's bad. Don't do it. Okay. I'm just saying. So if you're going to sell real estate and you've been conservator, do your due diligence, make sure it's a righteous deal, all the rest of that stuff, and then get a court order. Because if the judge doesn't look, squiggly eyed at what it was you're doing, you can almost be guaranteed that your family members are, or, the conservator's family members are, they're going to think you sold it for too cheap. And if there's any possibility of that, guess where the money comes from? You. Why don't do it? So okay. So that's the bottom line. If you're a conservator, and even if you think, and this is true too, even if you think you have the authority to do it, then you even if you think you have the authority to take the action, then still get the court to approve it. Let's see. How can a daughter? There's another one. How can a daughter get power of attorney? Does the parent have to agree? Hardy har har. Yes, the parent has to agree. That's the whole nature of a power of attorney. Okay, is that it's a voluntary delegation, giving up to someone else of the right to make decisions. Now, you're not giving up when you do a power of attorney. You still retain your own rights. So maybe giving up isn't exactly the right phrase, but the idea is that you've allowed someone else to make your decisions for you, right? Now, you can retain that decision-making authority yourself, but think how dangerous this is to give someone else the authority to make your decisions for you. Well, now they sell your house. Well, you said they could sell your house or do whatever with your bank accounts, whatever. And the fact is that in the meantime, you went and sold a house to somebody else. Oh, well, no, that looks like a great idea. And this is, again, you may have heard me say this before. You may have heard me say that we've got troubles with when you have two powers of attorney acting at the same time, because generally they each say that each one can act independently, which is what you need for the bank, for it to work. On the other hand, they could both be doing completely different things. So just have one person do it and be careful what you're doing. We have Tom on the line. Good morning, Tom. Welcome to the David Carrier Show.
Good morning. Thanks for taking my call.
You bet. How can I help?
The situation is I have a friend that she was a sole heir to everything. She had a stepfather that went into a care facility, and she was going to be in partial control of the multiple trusts. There was trust for the children. There was trust for family members. This secondary person was just a friend. He's not a family member or anything. Was in net control of the kids and the family members' parts of the trust. And then she turns out she's my girlfriend. She's what's in charge of, like, the condo and his assets and things like that. Well, he went into the care facility early December, and he started failing. And I explained to her she needed to get an attorney to find out what all he had for assets and things like that so he could be taken care of appropriately in a care home. So we'll bump forward. So it came to the 25th of December, Christmas. She was up to the family, and everybody went up to see him. And he was starting to fail. But she was there till like 11 o'clock, left, They called him and said, Paul, it's really failing. You need to come back. So she was there around 2 a.m. on the 26th of December. So it turns out at noon, and he was pretty much incoherent. He was on his back. Just the medication is the only thing that would actually bring him out of his fog or his haze.
Mm-hmm.
And so it turns out this other person that is just a friend went up, brought a notary up to the care facility and had Paul sign over total control of everything to this outside person, eliminating my friend from any control. Locked her out of the condo. It won't show her anything to do with any of the trust, or what he's being compensated for, what he's doing. I'm curious. I said by the first of January, he passed away the morning of the 1st of January this year. Is there a statute of limitations when it comes to getting an attorney to get involved?
Yeah, it's 2 years. Basically 2 years.
It's 2 years?
Yeah, but I wouldn't. I mean, this is a sort of thing where you need to jump on it. I obviously all I know is what you're telling me, which is that while this guy was pretty much incapacitated, somebody showed up with paperwork and a notary and redid his estate plan. Is what it sounds like, right?
Right, exactly. I'm telling you, he was on his back, basically mouth open, incoherent. How he was able to make any kind of financial decision, especially changing everything over, giving total control to a so-called friend, and eliminating my friend from any kind of access to anything, is I knew it was shady from the beginning. And
yeah, I tell you what, the music means I got to get out. But hang around and we'll hit this again in the last segment. Okay, Tom.
I appreciate it.
Yeah, sure. Hang on.
Okay.
Yep. Oh, you're listening. You're listening to the David Carrier Show. I'm David Carrier, your family's personal attorney. Welcome back to the David Carrier Show. I'm David Carrier, your family's personal attorney. Give us a call. Well, it's kind of late to give us a call, but you can always go to the website, davidcarrierlaw.com, or drop me an email, david@davidcarrierlaw.com. That's david@davidcarrierlaw.com. We're still doing the workshops. We've started yesterday, actually, a new program whereby if you choose to take advantage of it, we've drastically reduced the expense, the cost, the fees involved in getting your estate planning done. And what we're really trying to do, is give an option for folks to get done what they need to get done at a much lower cost. If you have a question about that, just give us a call and or drop me an email, and we can, we'll let you know what's going on, or come to a workshop, because we lay out the whole program there at the workshop. It's a way to make it available for more people not to go broke. And I think that's important. And we kind of figured this way out with some friends, and well, give it a try, see what you think. We were talking with Tom, Tom's girlfriend's dad, if I got the sequence right, died on January 1st around Christmas time, and the girlfriend was had been chosen to be dad's trustee, to be in charge. But then, as dad was failing fast, it turns out that a friend, quote unquote friend, showed up with a notary and had him sign a bunch of documents when his mental capacity was at best questionable. It's been since January, and no information from the friend, no disclosure about what's going on or how it happened or anything else. And family's starting to get a little bit frustrated in terms of finding out what's going on. And the question is, what do we do next? Is that about right, Tom? Am I summing up correctly?
Very accurate. Very accurate.
Okay. So the answer is, there are two ways to challenge someone's decisions when they do an estate plan. The first way is lack of mental capacity, and the second way is undue influence. Okay, those are the two ways. Now, with lack of mental capacity, if the hospital will certify that he lost consciousness or was simply unable to make any decisions for himself. And based on what you're telling me, sounds as if there might be some pretty convincing notes in his chart. Who knows? But sounds like, then that would be one way to prove that these documents should be thrown out and whatever was there before would come to the fore. Okay. And then you've got the whole other issue of liability on the friend. What was he trying to do? Was he attempting to take advantage? All the rest. So that's one way of doing it. I have to tell you that that's kind of difficult because, you've got a notary there who's going to, you would expect, would testify that, he may have been out of it, but then he was conscious and he was sharp as a tack while I was there and signed these things. And you don't have a witness to say no. And then it becomes kind of difficult to establish the lack of capacity, and that's going to be on you. But the second way is what we call undue influence. Did somebody in a position of faith and trust, right, benefit themselves from the decision of the person? So in this case, your girlfriend's father would be the person. And did this friend benefit materially from what was going on? Now, if somebody makes a decision and it's just kind of random, it's just kind of out there, then it's on you to prove that person used undue influence. And begging, pleading, crying, stuff like that is not undue influence. Okay, it has to be direct coercion. But if the person has a special position of trust with regard to the new trustee has a special, now it's on them to prove that there was no undue influence. And based on what you're telling me, it seems to me that the burden would shift to them to prove that there was no undue influence. I don't know how the heck you're going to do that. Now, what you need to do, because I'm down to, we're ticking down here anyway. The key here is to go with you need to get someone who's involved in litigation, someone who's willing to take on this kind of thing, because it's not easy. It's not small peanuts. You know what I mean? It's a big deal to get these things done. Now, do we have any idea what the amount of property at risk is? I mean, you said there was trusts and this and that. What?
Well, the condo is basically listed at $190,000. He's acquired a realtor and doesn't allow her to have any kind of access. I'm offering $190 for it cash, but there's something. He's getting some kind of cut from this realtor. There's the whole thing's been shady. I guess my basic question is, since we're running out of time, is that, but just getting an attorney involved and sending him a letter so she can see exactly what kind of assets and things he had, because she has no idea. You
need to invest. You need to invest. So Tom, here's what I'm going to say. You need to invest enough to get someone. You don't want to send them a letter. You know what a letter means? When you get a letter from an attorney, what it's saying is, I don't want to sue you. Okay. What you need to do is send them a complaint. Okay. I mean,
okay.
Because either you're going to be there or you're not. I mean, if this guy is willing to do what you've described, then, he must have calculated the cost of some of this in there. He's just going to blow past the letter. What you need to do is convince him that you're serious. This is just my general take on the thing. A good friend of mine's in litigation. That's what he does. And he says, we were talking about demand letters one day. This was years and years ago. And he goes, my demand letter is a complaint, because if I send them something else, all I'm telling him is I don't want to sue you. Well, then sue him. Great.
She needs to. Can she do a personal demand letter, or does it have to be a letter from?
No. I'm saying you need to get serious about this, because it sounds like right now, if he's not giving her any information at all, that means she was disinherited.
No.
Well, that's what it means, because if you're a trust beneficiary, you're entitled to a copy of the trust. You're entitled to the trust as it affects you. And if you're not getting anything at all out of him, what he's saying is there's no part of the trust that affects you. Okay, you're not a beneficiary. That's what he's saying. So you need to crack the egg, make some omelets here. Okay. You need to get real. I would suggest if you want to do anything about it, you need to get serious about it before this thing goes on any further. It's not a statute of limitations thing. It's he sold property, how do you how do you unbake a cake? It's pretty tough. So, much better to get involved early on is what I'm saying. And it's been a couple of months
That's what I
already.
was saying too.
Yeah, I totally agree with you. If you're going to do something about it, do
Yeah,
it now. But don't be one of these people who let it go and let it go and let it go and let it go, and then 10 years later they're like, "Oh, I should have done something."
Right, exactly. I'm with you, Dave. That's what I said. You're on the same page. That's what I was thinking. I just needed to know what direction actually to do. So I'll try and push the issue a little more with her, because that's the said she was counting on this for her retirement.
Well, yeah.
Things from her mom. It's sad all the way around.
Yeah. Yep. But you can't let the sadness and the grief distract you. Okay. Thank you. You've been listening to the David Carrier Show. I'm David Carrier, your family's personal attorney.